Today marks 10 years since the Supreme Court's landmark decision recognizing same-sex marriage. It's estimated there are more than 800,000 married same-sex couples in the U.S. That is more than double the number before the ruling in the case back in 2015. For tonight's interview, we're joined by CBS's legal contributor and Loyola Law School professor Jessica Levinson. Jessica, good to see you. So remind us, if you can here, what the Obergefell case was all about and how the Supreme Court ruled.
So Obergefell, exactly as you said, was about same-sex marriage, and the court essentially made two big conclusions. One is that the right to marry is a fundamental right, and this is something that the court had said, or at least alluded to, for decades. Think all the way back to Loving versus Virginia. And two, that you can't take that right away from people just because they want to marry a partner of the same sex. So it was really based on two parts of the 14th Amendment, both the due process clause saying it's a fundamental right and the equal protection clause saying you can't discriminate against people based on their based on whether or not they're gay or want to marry a partner of their choosing of the same sex.
So it didn't make a ruling on protections against discrimination for gay people. Do we have that right? And then how is that playing out before the court right now?
Great question. So the court's opinion was really about marriage, no more and no less. And there was a kind of macabre joke right after the Obergefell decision. Well, people can get married on Sunday, but fired on Monday. Now, I think that's no longer the case based on how we read the federal employment discrimination statute. But again, Obergefell was just about marriage. And so there certainly has been a lot of activity since then where we look at, can people be protected from employment discrimination, for instance, based on gender identity, based on LGBTQ status in general? There was another Supreme Court decision, the Bostock decision, where the court interpreted Title VII and said preventing discrimination on the basis of sex means preventing discrimination on the basis of sexual orientation or gender identity. But that wasn't part of that big landmark Obergefell decision.
So when people hear about this case, they think of Roe v. Wade. That's one of the first things that comes to mind. If the court was willing to overturn such a strong precedent as Roe v. Wade, what about this one? Is this protection vulnerable?
I'm so glad you asked that because we still talk about this. I still have my students ask about this. And I think the answer is, in my view, no, for a couple of reasons. One, I think the court doesn't want to go there. There isn't the interest in overturning this particular precedent. But two, as we talked about in the beginning, Obergefell is based on two parts of the 14th Amendment. One is the due process clause and the other is the equal protection clause. When you look at Roe v. Wade and the Dobbs decision that overturned Roe v. Wade, that's all about the due process clause. So even if you start saying we're not going to recognize any unenumerated right in the Constitution, I still think you have that equal protection leg of the Obergefell decision that's standing.
And real briefly here, what about state lawmakers? What are they doing to try to get the court to reconsider the situation?
Well, some are passing resolutions, hoping to push the issue, hoping that now, because the court is a 6-3 conservative court, a more conservative court than the court that made the Obergefell decision, that the court might take a case. I mean, resolutions are not legally binding. I will just say again, I don't think the court is likely to revisit the Obergefell decision anytime soon, and states cannot contravene that decision. That's a decision based on federal constitutional law, and they can't go against that.
Okay, Jessica Levinson, thank you so much for the insight tonight.